I'd like to pick up on that point to say a little bit more about remedies, using recent U.S. experience as a perspective for discussing some interesting issues that I think we are going to see surfacing in the next few years. And in the interest of time, I will try to go through this very quickly. The written materials available on the conference website contain a much more detailed discussion and citations for the cases I'm going to be discussing. The specific topics I need to be focusing on, no, thank you, I can do it, are what the alternatives available to solve a problematic merger are going to be, how the U.S. experience in some very recent cases might inform decision-making in this area, and then some of the policy questions that the agency needs to focus on as they consider these issues. And obviously, the focus of a remedy in a merger case is to restore the competition that has been lost through the combination in the transaction. Historically, the default merger remedy has been a structural one, and this is seen as providing the most effective relief because it essentially replicates the competitor that was lost through the transaction. Even this relatively straightforward process, though, raises a number of practical issues in terms of identifying the appropriate bundle of assets to be divested. Is there going to be a need for a whole separate agreement during the interim period before the structural relief can be accomplished? Are there going to be situations, as Bernd mentioned, where you either want assurances in the form of a fix-it-first remedy or a buyer identified up front as a precondition to getting the government approvals? These have been more and more common in the U.S. in recent past because of some difficulties in finding acceptable buyers after a transaction has closed. And even though the U.S. system routinely incorporates a trustee called a divestiture trustee to accomplish the sale of the assets if the parties are not able to find a buyer themselves, the length of time and in some cases dissatisfaction with the ultimate purchaser has caused the agencies to look for the greater approval rights in a buyer upfront scenario before they give approval to the transaction. Another development in the U.S. that you may have heard of is what is sometimes referred to as a crown jewel provision, which says if you are not able to accomplish the divestiture within a specified time period, we will put additional pressure on you to come up with that buyer by increasing or augmenting the number of assets that are going to be divested, so that if you can divest within 3 months, it's going to be asset package A, but if we don't approve a buyer within those 3 months, you have to add assets B, C, and D to the divestiture package in order to make it more attractive to get a buyer. So despite the claim that structural remedies are certain, simple, and sure, there are many complicated issues you can face in this area. On the other hand, behavioral remedies historically have been disfavored in the U.S. for a number of reasons. These kind of ongoing conduct restrictions are seen as requiring a need for extensive governmental oversight, which the U.S. agencies have historically resented. They feel they don't have the competency, the capabilities to provide that ongoing review of business activities. And behavioral remedies also are somewhat suspect because they don't necessarily respond to changing market dynamics. They impose costs, obviously, on the merging parties, but also on third parties to the extent that an arbitration process is set up in order to resolve complaints associated with the merged firm's activities. That obviously introduces a cost to other participants in the market. And for this reason, you have seen not just the U.S. agencies, but also antitrust agencies throughout the world take a generally dismissive and disfavorable tone toward the use of behavioral remedies in the merger context. And these are just selected quotes from a much larger litany that you can identify explaining why agencies feel that behavioral remedies should be disfavored in the merger context. There has been, however, a significant use of behavioral remedies by the U.S. agencies, and in particular the U.S. Department of Justice, in the recent past. And some very high-profile transactions like Live Nation Ticketmaster, which was also the subject of an extensive UK proceeding, the NBC-Comcast merger, the very recent Google ITA transaction, all have produced behavioral remedies from the Justice Department. And the written materials talk about the provisions that are incorporated in these decrees. You will see that they often contain very elaborate either firewalls preventing internal information flows, mandated access by competitors to certain products of the merged firm, opportunities for third-party arbitration rights, and a whole host of ongoing remedies intended to restore competition that the agency believed was lost by the transaction. You might ask, how can this be squared with the Justice Department policy statement that we saw on the preceding slide? And the answer is that most U.S. practitioners would say, no, they can't be squared. The Justice Department seems to be acting contrary to its own guidelines. And I can report on this front that since the materials were prepared, Christine Varney, the current Assistant Attorney General for Antitrust at the Justice Department, gave a press interview in which she indicated very shortly, which I would assume to be within the next few weeks, certainly within a month, you will see the Justice Department issue new merger remedy guidelines that will recognize an increased and enhanced role for behavioral remedies. So I would encourage you to keep an eye out for that development. We look to see a very significant change in the U.S. guidance on behavioral remedies in the next few weeks. And I hope that when these new policy statements are issued, it addresses some of the very real questions that have been identified by antitrust practitioners within and outside the government on the use of behavioral remedies. And I just offer these as a concluding topic for your consideration, because they have implications for other agencies throughout the world thinking about the use of behavioral remedies. And a very obvious starting point is, should behavioral remedies be limited to a relatively narrow category of firms or industries where there already is significant government involvement or government oversight of the industry? Communications, airlines, some other sectoral regulator being available and capable to address ongoing issues that might be associated with the behavioral remedy. Is there a role for behavioral remedies in purely horizontal transactions, or, as the majority of the cases in which the Justice Department has used them, should they be limited to the vertical area? Is there a specific term that you should consider for behavioral remedies? Normally, the Justice Department starts with a 10-year merger decree. There have been instances in which it is shortened, other instances in which the decree obligations go as long as 15 or 20 years. And is that an appropriate time period for having these types of behavioral remedies? The U.S. has a judicial proceeding for modifying Justice Department consent decrees. It is called the Tunney Act, and basically asks a reviewing court to approve and implement the remedy. Should there be a different standard for modifying behavioral remedies because of the likelihood that there are going to be changes in the industry, changes in the market during the course of the decree term? What would be the best remedies for monitoring compliance with behavioral decrees? Can you rely purely on private parties to invoke arbitration rights or other private rights of action established by the decree? Or is there a need for an ongoing government review at periodic interviews in order to ensure that the decree is still working? And indeed, a related question, should there be a mandated assessment of the effectiveness of behavioral decrees as part of the decree term itself, that at a periodic point, 5 years, 10 years, the agency step back and says, is this working? Should there be changes? And that, of course, poses the very significant question, if you determine there is a need for changes, how can you go about modifying the decree to accomplish that? And I'm glad to say that my last policy question, should the agency get its written policy guidelines in line with its actual practice, seems to be accomplished by the agency, and we'll look forward to that in the next few weeks. Thank you.